Well, hello ladies and gentlemen, I'm Philip Harris. I'm a partner in the construction department of Wright Hassall solicitors, and this is another in our series of Law Bites takeaways which we're running in the sort of COVID era as a replacement for our regular in-house sessions in the office. And this talk is on terminating construction contracts, how and why you should terminate them. So, most people will understand that simply claiming damages for a breach of contract and letting it run on isn't always the right thing to do. It's often an insufficient remedy. If the breach is fundamental and it goes to the root of the contract, then the contract needs to be brought to an end. It needs to be terminated. Under the JCT forms of contracts, there are significant advantages, which I'll run through, to being the party who terminates. But there are also, importantly, significant risks. If you attempt to terminate and do it wrongly, then you yourself could be in repudiatory breach, you could be the wrongdoer, and the contract can be terminated then against you. So when we're looking at the JCT contracts, it's important to note that the termination clauses are not exclusive. So you can elect to terminate under the strict provisions of the contract, or you can terminate at common law for a fundamental repudiatory breach, accepting that repudiatory breach as bringing the contract to an end. And if we look at the Bible on construction contracts, Hudson's Building and Engineering Contracts 13th edition, and then you'd find it in chapter 8 at paragraph 22. The fact that a contract provides an express right of termination will not, unless clear words are used to show a contrary intention, exclude the common law rights. So you can terminate under the contract, or you can just say, effectively, I've had enough, this is a fundamental breach going to the root of the contract, I accept it, and do that at common law. And Hudson cites the case of Architectural Installation Services Limited against James Gibbons Windows, which is in Building Law Reports 46 at 91, page 91. So at common law, the position is you can terminate at common law where the other party has made a sufficiently serious breach or has acted in such a manner to show that it no longer intends to be bound by the contract. Common law termination then releases both parties from future performance and obviously entitles the innocent party to damages for breach of contract. There are various grounds for termination at common law, and I'll just run through them. But one is the breach of term is so serious that it would be unreasonable to expect the other party to continue, so it's a fundamental breach. Secondly, breach of a term which is not sufficiently serious in itself, but is protracted or a repeated breach despite protest or notice from the other party. And so it shows an intention not to be bound. Thirdly, actually informing the other party that you've no intention to proceed with the contract or no intention to proceed with part of it, so whole or in part, that would be a fundamental breach, giving grounds for acceptance of repudiation. Fourthly, where the language of the contract shows that a breach of an obligation has the same consequences as a fundamental breach, so the contract talks about a condition, the breach of a condition. If you breach this term, that is treated as a breach of a condition. And finally, the common law, of course, recognises that if there are express provisions in the contract, you can terminate under those express provisions. So common law termination, to terminate at common law, there must be a clear and unequivocal acceptance of the breach by word or action. So action may be enough. A single breach of the payment obligations is unlikely to amount to a repudiatory breach, but repeated breaches of the payment obligation or refusal to pay or inability to pay may be a fundamental breach. And it's important to note, ignoring a repudiatory breach will affirm the contract so that it's seen as continuing. But of course, some breaches are continuing breaches in themselves, so you can accept the continuing breach as long as it continues and is sufficiently fundamental. So let's look now at the JCT contracts with a very light touch and overview. As I've said, there are significant advantages to the party who terminates. Using the design and build contract 2016, where the employer terminates for default or insolvency, firstly, he can require the contractor to remove himself from site. Secondly, he can obtain copies of all the contractor's design documents, get them back for himself. Thirdly, he can require the contractor within 14 days of termination to assign to him the benefits of agreements such as supply of materials and goods and subcontracts. And then no further payment becomes due to the contractor, and the employer need not pay the sums that have become due if he has properly served a pay less notice. So the employer is not required to make further payments or to release retention until he's had the work then completed by other people. So he has to pay sort of what he owes up to that point, unless he's put in a pay less notice, but he's got no obligation to make further payment or to release retention until the work has been completed by somebody else, and that under that replacement contract there has been making good. So you can see that if there was a year to run under the contract and the replacement contract takes a year, and then you have a rectification period of a further year, and then there's going to be some further period for making good, then it could be, well over 2 years before you even need to think about making any further payments as an employer to the contractor. Once you get to making good under the replacement contract, an account is taken within 3 months after making good. That account takes into account any expenses incurred by the employer due to termination and any direct loss and or expense caused by the termination, and it also takes into account amounts already paid to the contractor and the amounts which would have been paid on completion. And then the balance, whether it's due from the employer to the contractor or vice versa, becomes a debt. But you can see that very often in this situation, the employer is going to say, look, it's cost me far more to have this job completed as a result of your breach, as a result of the termination, and so actually you owe me money and I don't have to pay you any further money. Conversely, from the contractor's point of view, he will have significant advantages to terminating the employer for employer default. In general terms, the contractor simply removes himself from site, and then as soon as reasonably practicable, he prepares and submits his account. So you get the message that the person who terminates basically gets to take the account, and that account sets out the total value of work properly executed and design work, and any direct loss and expense and reasonable costs of removal from site, the loss and damage caused by the termination, and the cost of materials which the contractor has had to purchase because he's already got orders out for that material. And then again, after taking into account the amounts previously paid to the contractor, the employer then pays the contractor within 28 days of the submission of the account and without deduction of retention. So significant benefits to the contractor. He gets to take the account quickly on his own terms. In theory, at least, he gets paid within 28 days of the submission of the account, and there's no deduction of retention. He's not waiting for his retention. So I've just rather simplistically run through that from the contractor's termination point of view. If you want to look at the details, please go to 8.12.3 of the design and build contract. So there are certain requirements in respect of termination notices. And the courts won't necessarily strictly enforce the formalities of the notice provisions as regards the method of service or service on a particular location. And you can see that in Hudson's Building and Engineering contracts at Chapter 8, paragraph 41 in the 13th edition. But Hudson says, look, it's sensible to observe the strict requirements of the contract. And it suggests that different degrees of strictness may apply to the first termination notice and the second or final termination notice. The requirements may be stricter for the first notice than for the second notice. And Hudson goes on to say, proof of actual service, if relied on, will need to be made either to the stipulated address, even if by other than the stipulated means, or to a sufficiently responsible and duly authorised representative. In other words, you may not get it absolutely right in the way that you served the notice, but you must show that you've got it to the right address and that you've got it to the right party. And the contents of the notice must show that the invocation of the contractual remedy has been done with no possibility of doubt. So in other words, it's got to be clear that this is a termination notice properly terminating under the contract. And Hudson goes on, an attempted termination on good grounds, which fails only because the notice is defective in form, is not necessarily a breach justifying termination. So as I said earlier, if you terminate and get it wrong, you use the wrong grounds, you yourself become the wrongdoer and you can be terminated. And this is saying if you simply get it wrong on a technicality but your grounds are right, that doesn't necessarily mean that the other party is entitled to terminate on you. And finally, on that point, meticulous compliance with the contractual time limits has been insisted on by the courts. So whatever else you may get slightly wrong, they're unlikely to give you any latitude in relation to time. You must serve the notices on time if there's a time provision in the contract. And as I've said, the risk is that if you terminate for a fundamental breach, but you get the grounds wrong, then it was you are wrongful, your termination is wrongful, the other party can accept your repudiatory breach. So let's look again at the JCT design and build form of contract. There are specific provisions for termination by the employer on grounds of insolvency at 8.1, which I won't go through, they're not covered here. But for the other grounds, the default grounds, the termination must not be unreasonable or vexatious. It will take effect on receipt of the relevant notice, and there are specific formalities for serving notices in 1.7.4 of the contract conditions, which I won't go through, but for example, serving by special delivery would be one way of serving. The grounds for termination before practical completion include, firstly, the contractor wholly or substantially suspending without reasonable cause. So contractors need to be careful that if they're threatening or actually suspending, they're not suspending without reasonable cause. The contractor's failure to proceed regularly and diligently is a ground for termination. Failure to comply with a notice or instruction to remove works or materials not in accordance with the contract. So you're told to take it out and you don't do it. But it goes on to say, and the works are materially affected. So there must be an instruction to take out which isn't complied with, and that affects the works materially. And then failure to comply with the subcontracting and assignment rules, so subcontracting without consent, for example, and failing to comply with health and safety, failing to comply with CDM regulations. So for the employer to terminate, the employer gives notice specifying the default, and if it continues for 14 days from receipt of that notice, the employer may, on or within 21 days from expiry of that 14-day period, serve his second notice terminating the employment of the contractor. If he doesn't do it within 21 days, but the fault is repeated, then the employer may, by notice, terminate on or within a reasonable time after the repetition. So if there's a repetition, that gives him a second bite of the cherry, a second ground for serving his second final termination notice. And with termination by the contractor, the grounds include failure to pay, employer not paying, wrongful assignments by the employer, failure to comply with health and safety, failure to comply with CDM, or a continuous suspension due to the employer's default beyond the period allowed in the contract. And then the contractor gives his first notice specifying that default. And it's very similar to the employer's termination provisions. If the default continues for 14 days from receipt of notice, the contractor may, on or within 21 days, by a further notice, terminate the employer's employment. So the original default notice, and then you can serve the second termination notice on or within 21 days. And the same provisions where there's a repeated default apply in relation to the contractor as applied in relation to the employer. So if the employer repeats his defaults, the contractor can then, within a reasonable time, serve his second notice. And there are also provisions for termination for employers' insolvency, which I won't run through here. So that's a quick canter through, at a fairly high level, the grounds for termination and how you go about it. So I hope that's helpful. Thank you very much.